What's going on, everybody? I appreciate you guys and your patience. Um, and I wanted to welcome you to the video that we have going on today. We're going to be going in some great information. Okay, we're going to be diving deep into a topic that you may have heard discussed, and you may have heard it discussed in a different way, but we're going to bring it to you the winner circle way. Okay, so we're going to discuss equitable rights in criminal cases, and most attorneys may not discuss this. And this is not a gripe or a swipe at any attorneys, but most people only focus on statutes, penal codes, or rules of criminal procedure. Now, what people have to understand, there's no right way to do this. There's multiple right ways to do things. Don't stay stuck in one mindset thinking you know everything, when there's many ways to get stuff done. Okay, but what if I told you that every criminal case is built on contracts, trust law principles? Okay. And if you don't know that, you're playing the wrong game. So we're going to start out with the basis of equity. Equity is not just about fairness in legal terms, it refers to the body of law that supplements a rigid structure of statutes. It gives the judge flexibility to do what is right when the law falls short. So a lot of times we have to keep in mind that in law, the term equity refers to a particular set of remedies and associated procedures involved with civil law. So just like I told you in the last uh, video, or one of the videos I did, I showed you that Rule 1 and Rule 2 of federal civil procedure is showing law and equity being merged into civil law. Okay. So these equitable doctrines and procedures distinguish from legal ones. While legal remedies typically involve monetary damages, equitable relief typically refers to injunctions, specific performance, vacatur. A court will usually award equitable remedies when a legal remedy is insufficient or inadequate. For example, courts will generally award equitable relief for a claim which involves a particular or a unique piece of real estate, or if the plaintiff requests specific performance. So the distinction arose in England, where there were separate courts of law and courts of equity. Following this pattern in America, some states created chancery courts which deal with only equitable relief. So if you're in a court of chancery within your state, then you need to bring up your equitable rights. So there are certain courts that have chancery courts, and since they don't bring up equity in a chancery court, it is seen as a waived defense. Okay. So in other states, the courts of common law were empowered to exercise equity jurisdiction. Today, separate courts of chancery have largely been abolished. So you can bring equity up in any court case, as the same court that may fashion a legal remedy has the power to prescribe an equitable one. So that's what Federal Rule of Civil Procedure 2 is specifying to you. Okay? Courts are sometimes hesitant to impose equitable relief, particularly specific performance. This is because equitable remedies often require the court to monitor the remedies to make sure that the defendant complies with the court order. However, the Supreme Court has been willing to encourage the use of equitable remedies in certain areas of law. Okay, so a lot of times when we're going to court, there's people who speak the equity side, and they say that that's the only way you can get remedy, but you can also get remedy in the legal side. So you have to understand what is, in this case, what is the best option for you. So when you're dealing with situations in life, you want to make sure that you know what's the best option for you. And it's very interesting that sometimes people don't look for that. They look for um what they think may be the easiest, but you have to do what's in your best interest. So what we're going to now go over is I'm going to bring up the screen for you, and we're going to go over another uh, aspect, and this is equitable title. All right, so I'm going to share this with you, and you'll be able to see it. Eight or not. I'm just going to do it simply. All right, so we went over the definition of equity, and we went over kind of like a glance of how the setting up of equitable interest or equitable or equity started. But in many criminal cases, what you think is a direct accusation is actually a trust structure. Okay, so a lot of times people don't understand that you're sometimes you're arguing what you did or didn't do, and when by doing this you bring yourself into a legal aspect in a court case. Okay, the legal title, your name, and they always try to say in all caps. It doesn't matter if it's in all caps, uppercase, lowercase. If someone is using your name, however it's phonetically used, they're attempting to administer your estate. Okay, is being used and impose liability, but you hold the equitable title as the living man or woman. That distinction is everything. So now we're going to go into legal title, or I mean, equitable title. So if you remember, I did a video talking about the separation of legal and equitable title and the way that you can collapse it. So, equitable title refers to the right to benefit from and eventually possess property, even though the legal title ownership is held by someone else. So, in a court case, when the state or the county is suing you, they're acting as if they have legal title. This is why you have the legislature, this is why you have statutory law. These are legal aspects. Okay. It is essentially an ownership interest that allows the holder to enjoy the benefits of the property, like appreciation and value, while the legal title is still in a particular another party's name. So now you understand. But here is one of the keys to this. So when I used to teach, well, not used to teach, but when I teach people uh, the federal rules of civil procedure, um, it's very simple to understand them. And we're going to get into a very potent rule that most people forget. And I'm trying to scroll over here because it seems like I got too many too many pages up. So I'm gonna go ahead and close these out. We can get right to this. All right. So I'm gonna show you this, and I usually don't show this or usually don't bring this up on on public calls because there's gonna be a lot of controversy in regards to this stance. So to understand this, what most people have to understand, well, you don't have to, you can not understand it if you want to, is courts routinely deposit complaints and fines into the record under Rule 67. Okay, so this is a fiduciary move. They are placing property in a constructive trust and waiting for you, the beneficiary, to make a claim. If you don't, they treat it as abandoned. Okay, so when you're thinking you're going through a court case and you're arguing about all of this BS, and then I tell you, why are you arguing with these people? Why are you going into court? You understand, I have a little information or knowledge that you may not understand and you may not see. But see, Rule 67 is a deposit into a court. That'll explain this for you. A, depositing property. If any part of the relief sought is money judgment or the disposition of a sum of money or some other deliverable thing. Who is the deliverable thing? When you go into court and you start arguing with the court without asserting your status or your rights or whatever, they look at it as you agreeing to be the collateral for the claim. So a party on notice to every other party and by leave of the court may deposit with the court all or part of the money or thing, whether or not that party claims any of it. So this is how a police officer can get a traffic ticket to a district attorney, or the police officer could get it to a judge, and then the judge is sitting on the stand ruling on the traffic ticket like he has the ability to do it. And then you just go in there and you keep saying, Your Honor, blah, blah, blah. And they just keep looking at you like, what? Okay. The depositing party may deliver to the clerk a copy of the order permitting deposit. Investing and withdrawing funds. Money paid into a court under this rule must be deposited and withdrawn in accordance with 28 USC subsection 2041 and 42 and any like statute. The money must be deposited in an interest bearing account or invested in court approved interest bearing instruments. So you get it from the horse's mouth. So a lot of people who get on the comments and then they want to say, oh, this is not real and you guys are sovereign citizens and blah, blah. It says it right there, man. I don't have to argue. So how courts function and operate is through trust. So in United States versus Kraft, the Supreme Court, let me bring this case up so you guys can get a little knowledge about some of this. So, when you're talking to people in your family or other people, they may not understand, but that's why I try to break these videos down for you guys. So, in United States, did I bring it over there? I sure did not. Hold on. Let me bring this on over here for you. Sorry about that. All right. So, in United States versus Kraft, the Supreme Court affirmed that equitable interest can exist if not recorded. That means the court knows there is a trust. It is up to you to claim your interest. So when we go into this case, this is United States versus Kraft 535 US 274. This was done in 2002. So we're just going to go into the opinions. I really don't care about the context of this case. Okay, let's see what's the ruling, if they have it. I clicked a different link than I had. So let's see. I think what I'm gonna do with this. I'm gonna go over this case another time because I'm trying to power through this for you guys. So, and that'll make it a lot easier. So I'm gonna try to bookmark that, and if I forget about it, somebody, I hope you can remind me to do a separate breakdown video, and then I'll just go over that. Oh my goodness, my links ain't working. All right, so we're gonna go to standing. Now, the reason why we're talking about standing in a equitable case or a case in regards to a so-called criminal cases, because when a person is suing you, they don't you're presumed innocent until proven guilty. So what people do is they go into court, they start arguing. So then the court's like, oh, so you're arguing? Okay, now we have an argument. So now I have a right to adjudicate this matter, and I can wear any hat I want to adjudicate this matter. So you have to understand standing. So your equitable standing is what separates you from the legal fiction, meaning the legal person that's created. So as I told you guys, the legal fiction is not your uppercase name in uppercase. Your legal fiction is everything from your name, your address, your social security number, your phone number, your email address. All of that is a legal fiction because the illusion is that it belongs to you and it doesn't. You're just using it. Okay. You're not the defendant on paper. See, that's another legal fiction. So if they say John Smith, the defendant, John Smith, they're creating a legal trust. Okay. This is not for debate. I don't care if anybody, that's not true. It's a fact. So that's the trust. You're standing as the beneficiary, not the trustee who's liable. So standing or locus standi is the capacity of a party to bring a lawsuit into court. To have standing, a party must demonstrate a sufficient connection to and harm from the law or action being challenged. Standing in state court, because some people think that state court don't have rights. State court has rights. Okay, they have a right to administer court as they see fashion. In their fashion. Okay, a state's statutes will determine what constitutes standing in that particular state's courts. These typically revolve around the requirement that the plaintiff have sustained or will sustain a direct injury or harm that is harm that is harm is redressable. Okay, so a lot of times when people go into court, they don't make the other person prove their injury or their harm. So it's standing in federal court at a federal level. Legal actions cannot be brought simply because individuals have constitutional authority to resolve actual disputes. See controversy. So in Luan versus Defenders of Wildlife, 90 through 1424, 504, US 555, 1992, the Supreme Court created a three-part test to determine whether a party has standing to sue. Remember this, people. Remember, if you don't remember anything I say in this video, remember this, because if you're bringing a case or you're suing someone, you want to make sure that you hit these points. Okay? Injury in fact. The plaintiff must have suffered an injury in fact, meaning that the injury is of a legal protected interest, okay, which is a concrete and publicized and be an actual or imminent casual connection. There must be a casual connection between the injury and the conduct brought before the court. So that means if they send you a letter and they say, "Hey, you owe us $200," or they send you a phone call and they say you owe us $200, and they put that information into the court, they're saying, "Oh, that establishes a connection between the parties." Just like I say, it's not always minimum contact; it's prima facie evidence. Because if they put prima facie evidence saying that there's an agreement between you and another party, and you sign that agreement, then you can say, "Hey, I signed it, but I have an equitable right to the proceeds in that agreement. I don't have to argue with you." Redressability. It must be likely rather than speculative that a favorable decision by the court will redress an injury. See, the courts are not supposed to cause injury, they're supposed to restore people. So, one of my videos I talked about where I said the other party cannot make you pay unless they have evidence that they did a disbursement. Okay. Now, when I said that, someone asked me, what did I mean by that? What I meant was if you don't have any evidence that you paid something out, that you lost something, then you can't bill me for it. So what they do is they create a bill, which is prima facie evidence to which you can use in any format that you see fit to settle, get rid of, or whatever to any obligation. Okay, I hope people understand that. So we already went to equity and how you can, the understanding of equity and the definition. So instead of fighting jurisdiction blindly, you can invoke equity. Okay. So that's one of the cases, the things you go into so called criminal court, they'll tell you you can't do this. And that's a lie. But a lot of times people don't understand what to do when they get in a situation. And it's hard to make a video that deals with every situation. Okay. Request the court review the matters under fiduciary duty, under due process, or under a beneficial interest. This isn't magic, it's real law. So we're going to go over what the legal definition of a resident is, and this will hopefully help some of you guys in regards to why I can't find why my leaks aren't working. We'll go ahead and it's been interesting. Let's see. I'm gonna get it. All right. So I'm gonna share my screen with you and we're gonna go over this. So a resident is a person who lives in a particular place for the indefinite future. Federal courts may determine whether a person is a resident, also referred to as being domiciled, of a state to determine whether diversity jurisdiction exists. And if you want more explanation on diversity jurisdiction, please go watch my video talking about Dred Scott in the Dred Scott case. Because there's a lot of great information in a lot of my older videos. You see the ones with no views and low views. I'm not sending you there because they don't have any views. I'm sending you there because there's a ton of information that people were not ready to get at the time. So, for example, in Baker versus Keck, the Eastern District of Illinois ruled that a person who was in Oklahoma for several years voted there and can't even say it right now. Oh my goodness. Okay, this right here. Oh, okay. And participated in community events, was a resident of Oklahoma for the purposes of federal diversity jurisdiction. So what does that mean? How does a court prove that? Prima facie evidence, as I've told you, it's not minimum context, it's prima facie evidence. The prima facie evidence forms a minimum contact. So if the person doesn't object to the evidence that they used, then that forms a minimum contact. So, what are your response? What can you do? So you can do an affidavit talking about your equitable rights or your equitable uh, um, defenses or equitable standing. You could do a trust. You can demand for a proof of claim. Narration. So, if you're facing charges, you don't respond with a plea. You establish your standing and demand proper accounting. You declare the constructive trust or assert an equitable interest. Okay. So imagine basically you have to understand that if you don't assert your rights, a court will assume you have none. So imagine if the general public knew this, like if they knew that, hey, I don't have to go into court and argue with these people. I can basically raise up my rights and assert my rights. And if they abridge my rights, then we can go dance wherever we want to. This is the things that I was teaching a lot of you guys that you didn't understand. I was telling you guys that when they abridge your rights, from there you have a right to escalate it. This stuff is not very difficult to understand. What they inundate you with is fear. So since you have fear in your heart, I really don't have no fear in my heart. So when I go up against these people, I just don't deal with them. Like I don't have fear. I just there's a thing that you have to do with using your energy. I rather preserve my energy to fight wars than fight battles. They'll proceed under trust and contract presumptions that you never rebutted. But now that you know, you can change the game. So if you like videos like this, like, subscribe, click the bell so you can get any updates. So this is not, me begging for likes and begging for stuff. No, if you want to get this information, or you want to see my videos coming forward, it's best to hit the bell, because sometimes what YouTube will do is, and I'm not talking crazy about YouTube, but sometimes what they'll do is they'll shadow ban you. And if you don't know what shadow ban is, it sucks. It sucks, because, like, no matter how many videos you make, no matter what the content is, no matter what the algorithm says, your videos won't grow. And with that being said, I thank everyone for your patience. I thank you guys who have subscribed to the Winner Circle YouTube. I thank you guys who have subscribed to the Winner Circle 2 Instagram. And we're going to keep it rocking and rolling.